Hey everybody, we're getting a start by picking up a little washcloth to clean up my mess. Let's see here. I have to reposition the camera. I'd like to welcome Daniel Armendariz to Polynomial's little web presence. Daniel is a fabulous human being, and he knows a lot about tenants' rights, and he's giving up his wonderful Saturday morning to come and help all of us learn some shit. So let me fix this camera, and then we'll start asking him some questions. I'll just hide them. That's good right there. That's Tim Coronado's art in the back that you see from Queer Bomb. So this is an Althea Trix wig. Love her. Okay, Daniel, how are you today?
I'm well. How are you?
Well,
You're beautiful.
Thank you. I appreciate you. I think that you're like one of the most, I want to say, inclusive Latino men that I know, which is why I thought about asking you right away when I thought about doing this kind of stuff. So let's start with what you think about how people should view searching what their rights are if they're in a situation where they're not really clear what their rights are in respect to having a lease or not having a lease but living somewhere and maybe coming up against some unfortunate circumstances like threat of eviction or somebody just saying, hey, get out today, or I don't know, things like that.
Right. So just a little bit about myself. Today, as you said, I'm just sort of speaking as a private citizen, but I do work for an organization, nonprofit, that works on tenant rights for Texans, specifically anyone who rents a residential dwelling in Texas can contact the organization I work for and ask for guidance and counseling, and I've been doing that for about 4.5 years. So you know, not a lot of people know this, but about 50% of several of the major metropolitan cities in Texas are tenants, residential tenants. And currently, there's no organization representing those folks at the Capitol. So basically, they don't really have a presence or a voice at the legislature. Our organization, the organization that I work for, which is Austin Tenants Council, and again, I'm just speaking for myself today, but that organization is a nonprofit. It's a civic organization. It gives education and guidance. It doesn't give legal advice, and it's an advocacy organization. So, sort of in my daily duties, I'm counseling folks on practical advice on their rights as residential tenants. And what I would say is, if anyone out there who rents an apartment or a duplex, really it doesn't actually matter what you rent. If you pay rent to somebody, okay, you pay rent to a landlord, and that rent doesn't even have to actually be money. It can be services. So some folks enter into agreements where, they tell their landlord,
your store or something.
yeah, or they tell their landlord, I actually had a client some years back who was a mechanic, and the owner of the shop allowed him to live in a little house behind the shop, and basically he worked in exchange for his work. He was allowed to live there. So in that case, his rent was his work, his labor. That's still rent, and he's still a residential tenant, and he still has rights under the law in Texas.
How do you prove that you paid your rent?
Well, in that case, his proof would be the fact that he showed up daily to work. Okay, so that would be his proof. But for the vast majority of tenants, obviously, um, to prove that you pay your rent, um, you need to get a receipt. Basically, you need to get a receipt for the rent that you pay. And
So like, let's say I don't have a bank account and I get a little money order and I keep my little stub. So my little stub is my proof, right? That
that
I paid my rent.
right, that's actually not the case. So
Why
and
not? I bought the money order.
right, and so your money order really just proves that you walked into HEB and you bought a money order. That's all that proves. What you want to prove when you pay rent is that you actually delivered the money to the landlord on time and in full. How do you do that? You need something from the landlord in return for that money to prove that you actually delivered it. And most people would call that a receipt. A lot of times it can,
Okay.
a lot of times a landlord won't give you a receipt. And one thing folks should understand, and it seems commonsensical, but it's actually not. It's not required by law. Is that if you pay rent uh, any way except cash, you don't actually have a right to a receipt. So there's nothing in the law that says a landlord must give you a piece of paper acknowledging that they received your rent if you pay rent with a check or a money order or a cashier's check or a bank check. The only time that the law requires that a landlord give you a physical receipt is if you put cold hard cash in their hand. So,
Okay. So it seems then that a money order is not going to be a great way to pay rent then. So a cashier's check, you just go and give your money to the bank and they give you a check and whoever cashes it has to sign it, right?
so no, a cashier's check. Basically, what you'll do if you get a cashier's check from a bank is it's going to come with two sides to the check. One's going to be the check, and the other's going to be a receipt. There's no signature required. You fill it out to, or the bank fills it out to whoever you're paying, and you're going to hand. It's just like a personal check, except a cashier's check is trackable by the bank. It's backed by the bank, so you can, and it's a good way. It's a really good way to pay rent because you can track it. Money order is really actually the money order and cash are the two worst ways to pay rent. Um, Cash for obvious reasons, but money order because I don't know if folks out there have ever bought a money order and lost it, but it's hell basically trying to track it down and prove whether or not it was cash. You actually have to pay a fee to the money order company. Yeah, they can take like up to 90 days. It's ridiculous. So it's not a good way to pay rent um, because it's in effect, uh, it's basically you're almost losing your money if you physically lose your money order. And when you think about it, a landlord, uh, not that all landlords would necessarily do this, or even some, but I have had clients who have told me that their landlord was taking their money order and holding it past the deadline, and then after the deadline, telling the tenant that they had not received it on time, and then charging the tenant late fees. Because unless you get a receipt, there's actually no way to prove that the landlord physically received the money order at the moment that the tenant claims they did.
So, okay, let's go back to the cashier's check. So if I get a cashier's check, the bank's going to put a date on it. But that doesn't prove when I give it to the landlord.
Well, that's right. It just proves when you got it.
So if the landlord doesn't have to sign my receipt that I keep from the cashier's check, how else can I prove it? Like if I have a predatory landlord that's that way,
Right.
right? How could I possibly prove that I paid rent?
Okay, so what I always count when I'm working, what I always counsel folks is they need to take, they need to deliver their rent in a way that's provable. Okay, they need to physically deliver their rent in a way that they can prove that they actually did it at the time that they say they did it. So that means when you're living in an apartment complex, assuming that your landlord keeps regular hours, you physically take your rent down to the front office with a witness. So you take a friend who's over the age of 18 to personally witness that you delivered your rent at the time that you say you delivered it.
What if you have no friends or no relatives or no?
So in the state of Texas, and again, I'm not a lawyer, but in the state of Texas, you can actually record another individual, either audio or video, without personally, if they're physically in your presence, it, on your phone, in effect, and that's legal. And you don't have to tell them you're recording. Okay. So, for example, if you and I were sitting in a coffee shop and you put your phone down on the table and hit record, and you were recording our conversation, and you did not inform me that you were recording that conversation, in Texas, that is legal. Okay. Now, one thing I would caution folks who are listening is if you're on the phone with somebody, um, you have to be very, very careful about recording a conversation because you can never be certain whether that individual is actually physically within the solid boundaries of Texas or if they're in another state. And if they happen to be in another state and you're recording them, you could very well be violating that state's laws. So my recommendation to answer your question is that the tenant goes to the front office. Hopefully they have a phone that can record the interaction. They literally walk up to the person behind the front desk and say, "My name is so and so. What is your name?" You get that on audio or video, and then you say, "I'm here to deliver my rent. Today is such and such a date, and this is the time. Thank you for receiving my rent," and then walk out. Now you have a recording proof, which should be admissible in court if the landlord were predatory and decided to
Keep your money.
yeah, keep your money or claim that you didn't pay on
So
time.
so that they can get late fees, right?
Well, that's right. That's absolutely right. I mean, that's really
A side hustle.
that's right. That's right.
Dirty landlord side hustle.
Yes, and I've had clients. In fact, I had this poor fella who had to pay rent through the mail because his landlord was in another state, and he would mail his check to the landlord, and the landlord kept sending him letters a week later telling him that he got the rent late, and because the tenant was sending the rent through the mail, simply regular mail, he had no way of proving that the rent was actually getting to the landlord at the time that he claimed it did. In other words, he would tell the landlord, "Hey, listen, I sent this rent 2 weeks ago. It doesn't take 2 weeks for a standard letter to get to Colorado. This was not late." And the landlord would claim that it was, and he simply had no way of proving it because it was just regular mail. Which is why I recommend, if you have to send the rent through the mail, that you always do so certified mail, because that's trackable and that's legal notice.
So it seems like it's going to be in somebody's self-interest, to make sure that they can prove that they're paying their rent on time. And the best way is going to be to use certified mail, a personal check, or to record the transaction in some way.
Right, to personally deliver it and then record the transaction, the delivery of that rent. That's right, and all of this sort of underpins the basic notion that in Texas, unfortunately, it's sort of one of the more brutal states in terms of paying rent with respect to the law. In effect, if you are a dollar short and a day late, the landlord would have a right to refuse your late rent and then issue a notice to you demanding that you leave, that you vacate. Now, that notice, which is called a notice to vacate, is merely a demand. It's not it's not a legal. It is a legal notice, but it's not a legal demand in the sense that the landlord cannot have you removed. You have every right to stay there, but but it does give the landlord the legal right to make that demand to basically surrender the property. And if you don't within the deadline in that notice, um, then an eviction is imminent, very likely.
So they can just say, I want you out in a couple of hours, get out.
Technically, if the lease says so what the law says is that a landlord has to give you a physical notice, a physical letter, delivered in a very specific way, and there's certain ways that they have to deliver it within and give you 3 days to vacate, okay, to surrender the property. That's what the law says. But the law also has a provision, which I feel is unconscionable, which basically says it actually it doesn't basically say it says this precisely. It says unless a shorter period of time is contracted for. So in other words, if you sign a lease that says you have to be out in 5 hours, if you're late on rent,
if it's in the paper,
that's
it's
right.
In the contract.
If it's in the contract, you sign that contract and it says you have to be out in 5 hours or 24 hours or anything short of 3 days, that's perfectly legal.
So what you're saying is that nobody's special, that you are bound by whatever it says in the contract, and it doesn't matter how pretty you are, how much money you have,
or how that's right.
Going down.
Well, that's right, and it doesn't matter if you're physically disabled. It doesn't matter if you're 80 years old and you're living alone. It doesn't matter if you're a single mother with 5 children and you have nobody in the world and you don't have a truck or the money to hire movers. None of that is relevant with respect to a situation in which the tenant, for no lawful reason, hasn't paid rent on time. You know, if you got to pay for your kid's teeth cleaning because he's got a toothache and it's excruciating, and that's your rent money, and you don't pay rent on time, and you've signed in a lease that the landlord can ask you to leave within 24 hours, then that's exactly what the landlord can do.
Okay, so let's say that I'm the mother, right? I'm the mother of like some healthy babies because they would be healthy, except for their teeth, right? And let's say I had to spend all my pennies on their teeth, and then the landlord says, Mother Hubbard, here's a little paper that says get out, right? So I panic, and then I find my paper that says yes, I do have to get out within 24 hours, like it says on the paper that he gave me. And then I'm like, okay, so where am I gonna go? I don't have any money. I have nobody. Let's say I've borrowed money from everybody that I can borrow. Let's say I've hit up every agency in the world for free money or for emergency money, and I'm no longer eligible, right? So let's say, can I talk to the landlord anyway and say, hey, landlord, give me a chance. Like, this is my situation. I'm a mother of however many kids. Can I still just talk to the landlord and say, give me a chance?
Yes.
Don't take me to court. Like I know this notice is the beginning of a process, but you still haven't gone to the court and said I want a court date.
Right.
So when they go when the landlord goes to the court and says I want a court date, what does that mean?
Well, that means that they filed the eviction, and a eviction hearing is imminent. But you touched on a great point. If the landlord has not filed the eviction, and everybody listening, this is a critical point. If you're in a situation like this and you're on hard times, and the landlord's saying, you need to get out, I'm going to file an eviction in 3 days. The critical point to understand is until the landlord files that eviction, if you don't have an eviction on your credit already, your credit is clean in that respect, and you still have a very, very good chance of finding housing elsewhere if you're able to afford it. So the absolute critical thing to avoid is the landlord filing that eviction. So there's 2 things going on here. One is a notice to vacate, which is a demand for possession of the property. The landlord saying, get out in 3 days or 24 hours, or I'm going to file an eviction. That's just a request for possession. You have every right to stay there, and you're not breaking a law by staying in your dwelling. All you have to know is if you stay beyond that deadline, they're going to file an eviction. But that's the thing that you want to avoid. You want to avoid the eviction filing because once the eviction is filed, it's my understanding in the state of Texas, the mere act of filing an eviction will hit your credit, okay? And there will be a reference on your credit that an eviction was filed in some manner. There will be a reference to an eviction, and that reference will stay there in perpetuity. In other words, forever. It's my understanding that it's not subject to the 7-year rule, where things have to fall off your credit. And the burden will be on you to dispute it with all with the 3 credit bureaus to have it removed. Okay, and I'll tell you, if you're late on rent for no good reason, you're going to lose that eviction, and you will not be able to have that eviction removed from your credit.
Is there a good reason?
So, okay, so that's a different conversation.
Okay.
There are several reasons why rent. I should be careful what I'm saying. There's usually no good reason to withhold rent. Okay, so we always counsel folks never withhold rent. There is no good reason. Um, but there are several reasons why you could terminate your lease and move, and thus not pay rent in the future because you've left. And those are different issues we can talk about. I just want to finish by saying that that for because specifically because in Texas and in sort of the greater Austin area, the market's so tight. There are so many folks who are living paycheck to paycheck, and who are barely making the rent, especially with this recent government shutdown. That that the eviction filing is what you want to avoid. And going back to your question, can you talk to the landlord? Yes, absolutely. An individual's right to contract with another individual in the state of Texas. It's not absolute, but the courts give it great deference. And again, I'm not a lawyer. By that, I'm just saying that you always have the ability to speak to the individual that you contracted with to amend the contract that you have. So your contract, your lease is your contract, and it says you got to pay rent on the third, on the first, late on the third, and then the landlord can ask you to leave thereafter. And if you're on hard times and you miss rent and he gives you a notice saying get out, there's nothing legally preventing you from going to talk to the landlord. Now, if you have a landlord with a conscience, or you appeal to their better nature, certainly if you can work something out and say, listen, will you give me 3 days more? I promise to vacate if you promise not to file the eviction. I'll promise to set up a payment plan. I'll promise to do X. If that's the case, if that's what you're doing, my only advice, and this is the most important aspect of this point, is any agreement that you come to with the landlord in a situation like that where you're basically at a disadvantage because you've missed rent, any agreement that you come to should be arrived at in writing, and both parties need to sign it, and you should understand what it says, the terms of that agreement. And in that agreement, I would highly recommend that you don't sign anything that doesn't require the landlord to promise not to file the eviction if you come up with your side of the agreement. If it doesn't contain that language, then the landlord, depending on the spirit of the agreement, very likely would retain the right to file the eviction. And you want the landlord to promise not to file the eviction because that is the critical thing which will save your credit and give you the ability in the future to go find housing.
Okay, so going back to what you said about recording in audio or in video, could you do that for this, or does it have to be in writing?
Well, you could. So in the state of Texas, an oral agreement can be a contract. There's certain elements that have to be met in order for that oral agreement to rise to the level of the legal level of a contract. And again, I'm not a lawyer, so I'm not going to get into that. But but oral agreements can be contracts, and there is legal precedent for that. It's when you're dealing with a landlord, and because most folks, at least in my capacity, uh, working for that nonprofit, um, most of those folks don't have the money to hire a lawyer, so they really need something in writing. They can't they shouldn't rely on the possibility that they're going to have to go to court and argue that the landlord made some sort of verbal agreement. Okay, because the landlord, that's not in the landlord's interest, and all they have to do is deny it. If you don't have a witness who's credible to testify to the fact that that oral agreement was made, then it's just he said, she said. So you always want something in writing, always, and you always want it executed by both parties.
Signed.
Signed, physically signed. So the landlord needs to make their mark. You need to make your mark, and actually the terms need to be um, so they need to be signed, and then the contract itself needs to be delivered. In other words, there needs to be an exchange of terms. So one party should get a copy, and the other party should get a copy. So again, even with written agreements, there are certain elements that need to be present in order for that thing that you sign to rise to the level of a contract. The most important are the terms need to be in writing. Um, they need to be clear. There needs to be sort of mutual agreement on the terms, what they call a meeting of the minds, um, and uh, and then there needs to be delivery. There needs to be delivery of the contract. So I give you the agreement, you sign it, you give me the agreement, I sign it. That's delivery. So
That's awesome. So I have like some questions that I think come up for people when they're in a relationship and things go bad. So let's say that I'm renting a place and then my partner decides to be violent, but my partner doesn't live there. And I don't feel safe anymore living there and I just want to get out, but I have a lease. From what I understand, that one is pretty clear cut. If I make a report that I was assaulted by my partner, I can get out of the lease. Is that right?
so so there's a provision in state law with respect to what they call the situation you described would fall under the family violence provision in Texas. Now, so my understanding that so specifically within Chapter 92, which is the law that governs the relationship between a landlord and a tenant, um, the provision for family violence. There's several aspects to that provision, but the example that you described is one in which the individual who assaulted you is not your co-tenant.
Right.
Okay, they're somewhere else,
Right.
and they come and assault you at your location.
Yeah.
Okay, so in that case, um, the best thing that you can do is call Austin Tenants Council, because they will help you. They'll help you understand your rights, and very likely in that situation, because we're not experts in domestic violence. Um, Very likely what we would do is refer you to Safe Alliance. Okay, we have a relationship with Safe Alliance, and they will hear your situation and see if they can assist with you. Now, specifically with respect to the situation that you described, the property code addresses a gives you protections if the individual who has assaulted you is a co-tenant. Okay, um, and there may be other situations, but I know for a fact that the reason, sort of the spirit behind that law, was to protect somebody who is living with somebody who is also a tenant, falls under Chapter 92 and that statute, um, and has assaulted you in your dwelling. Okay, so prior to this law, there were situations where your roommate assaults you, and you had no legal protection, or no sort of a remedy, rather, to sort of extricate yourself from that situation, to get out. Okay, so the family violence provision talks about a situation in which a co-tenant who lives with you assaults you, you have the right, and we should make it clear, domestic violence can be other things than physical assault. It can be emotional abuse. It can be intellectual abuse. It can be various things. It's not just physical assault. But in that situation, the best thing for a tenant to do is to call us, and then we're going to give them information, or call us tenants council. We're going to give them information on how to obtain what's called a protective order. And the protective order is a legal order by a judge um, that's issued to a tenant in that situation, in which basically the order allows the tenant under the family violence provision to provide that order to a landlord to vacate the property. Now it's more complicated than that, unfortunately. Um, the law basically, there's two scenarios in which one scenario in which if the person lives with you, um, you have to give, unfortunately, you have to give 30 days notice. You have to give a 30-day notice to the landlord, okay, prior to vacating, okay.
If your co-tenant assaults you.
No, so if they live with you, you don't have to give that 30 notice. If they don't live with you, you have to give that notice, okay. Um, and and to me, that's just sort of personally, that's sort of reprehensible. I mean, in no circumstance in which you've been assaulted by somebody who knows where you live should you be required to give a landlord 30 days notice. You may not have 30 days,
Right.
okay, because they know where you live. So, but that is the case right now. And actually, as we speak, there is legislation which is being introduced into the legislature, which is it's a good bill, which would allow, because currently this is not the case, would allow a tenant to obtain what's called an emergency protective order. And based on that, obtaining that emergency protective order, the tenant would be able to terminate their lease and move. But that is not the case right now. So in a case where a tenant is assaulted and they go get an emergency protective order, which is an order, to my understanding, an order that is um, issued directly by a court, by a judge, without you having to go through sort of the the interview process that you would normally have to go through with the county attorney's office. That order currently, with that order currently, you can't terminate your lease. This bill would change that, which is amazing. That bill may do other things, but I know that's the key element of the bill. Protective orders, like I said, I'm not an expert in domestic violence, and Austin Tenants Council as an organization really isn't. That's not the expertise. So we do give advice based on the family violence provision in the property code, but we also refer to Safe Alliance because they're the experts. That's what they do. That's what they know.
So the number to call to ask questions, if you're in what counties do you serve for the phone line?
So again, so Austin Tenants Council serves for the phone line serves Williamson County, Travis County, and Hayes County.
And that's the 512-474-1961. So that number is available Monday through Thursday, 9 until noon, and rather Monday through Friday, 9 until noon, and then on Fridays it's only, and then it's also open from 1 to 4. So let me say that again. Monday through Thursday, 9 to noon, 1 to 4, and on Fridays only in the mornings from 9 to noon.
Right.
So the website is housing-rights.org. rights.org. So if you don't live in these counties, can you still use it?
So obviously you can use any resources available on the website. There we do have or Austin Tenants Council has an online service which is restricted to certain counties. I believe it's Hayes and Travis. Not sure if it's Williamson, but in effect, the law that Austin Tenants Council councils folks on um, applies to anyone in the state, right? Anyone who's a residential tenant uh, that falls under the protections of Chapter 92, um, that's 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 who Austin Tenants Council will serve. Now, um, we have Austin Tennis Council has various programs, and each program has certain eligibility requirements. If you can, if one of them, one of the programs is sort of a person in-house, person-to-person counseling session, and that really is open to anyone in the state if they can get their physical body to a location where Austin Tennis Council is counseling. If you're outside of certain counties, there may be a small charge of $15, but that specific program is open to literally everyone in the state. As a practical matter, most folks can't travel several counties, so primarily they're serving Williamson County, Travis County, uh, and in some cases, folks from Hayes come up. But um, but
So
yeah, there's a variety of programs. I think the most useful one, sort of in the short, immediate term, is their counseling line, because basically anybody can call uh, and uh, and and give the organization an address, which is in uh, Williamson, Travis, or Hayes County, and we will talk to you. Or Boston Tenants Council will talk to you.
that's perfect. So if people are not in these counties that are served by the Austin Tenants Council, would you suggest that they go to like their local legal aid and describe what's happening and see what they should do about it?
Yeah, that's yeah, that's really yeah. So Austin Tennis Council is unique um, in in the state of Texas, in that they're the only organization serving uh, residential tenants, um, sort of with the broad scope of services that they provide. There are a few other organizations, but their focus is more narrow, and they don't have as many resources. There's an organization up in Dallas. It's a union. It's called Texas Tenants Union. They do excellent work, but it is a union. You do need to pay a small fee. I think it might be somewhere around $25 a year. It's a very small fee, and that affords you, I believe, the right to attend these weekly housing rights sessions they have. Um, it's a small organization. Again, they do excellent work, but it's a massive metropolitan area that they're serving. There's no organization, to my knowledge, in Houston giving any advice uh, as an organization in terms of their scope and their purview on tenant rights exclusively. Um, there are some fair housing organizations. Obviously, the city of Houston has a fair housing office, and so does Dallas. In San Antonio, there's no tenant rights organization. There's a fair housing office. Um, so Austin Tenants Council is unique in that respect, in that it's addressing not only fair housing issues, but also landlord-tenant issues as defined by state law, and providing a sort of a broad gamut of programs to address a variety of issues, not just um, people who might be facing eviction, but if you have a repair that a landlord is not making, and that repair is a threat to your health and safety, whether it's a rodent infestation, or you have a leak, or you don't have any AC, you can call up the Tenants Council, and if you qualify, they have a program for that. So there's a variety of issues affecting tenants that Austin Tenants Council really is unique in their place in Texas in terms of the services that they're providing.
So if you're a tenant, um, but let's say you're a tenant and you feel like you're a tenant, but the law says maybe you're not a tenant. For example, the way I've understood um, an RV where it's not a residential tenancy is because you can drive away with it,
Right.
right?
Right.
But I mean, what about like that cute little place that's over there by Barton Springs? Those are like little travel trailers. They're not tenants. They look like they've been living there for a long time.
Are they mobile homes?
Well, they look like those little silver bullet trailers,
Oh, right, right,
right?
right.
Aren't those RVs?
Those are those
So,
are yeah.
but they have like their little gardens and like a little
Right.
chair.
Right. Yeah, and people actually are using those as their primary residence and living there all year long. Unfortunately, and they may or may not know this, I don't know which session it was, but sometime in the recent past, it might have been in 2014 or thereabouts, the Texas legislature, in their wisdom, saw fit to strip uh, the protections, the tenant protections, tenant rights protections afforded to RV owners, um, to strip them out of Chapter 94, which is the statute which governs manufactured tenancies. So previously, recreational vehicles were included, and if you lived in a recreational vehicle and it adhered to the definition in Chapter 94, you were afforded the rights of a tenant, and that is no longer the case. So those folks, even though what you see there appears all but permanent, the fact that they can hitch it up to a vehicle and pull it away within 24 hours, the fact that it's an RV, a recreational vehicle, basically means that they don't have, at least that that situation does not any longer fall under the property code. So so now I have to clarify. That doesn't mean that that you can't have a tenancy. So a tenancy is the establishment of uh, of a contract, basically, between a landlord and a tenant. A person, the law basically defines a tenant as somebody who pays rent to a landlord according to the terms of a lease, to the exclusion of others. Okay, so those are the elements that define a tenant. Um, so in theory, you could live, you could live in a cardboard box, pay rent to somebody, have a written lease, exchange rent on a regular basis, and have a tenancy. Um, that doesn't mean that that structure that you're living in adheres to local code and ordinances of what is and what isn't intended for human habitation, that sort of thing. Um, so, so Chapter 94 basically, with respect to with what is covered, mobile homes, um, you basically have a right as a tenant if you live in a mobile home. If you rent the if you don't own the structure, okay. If you own the structure and you're renting the lot, um, in terms of so if you own the structure and you're renting the lot, you don't have a right to ask the landlord to come fix your bathroom leaky faucet.
Right, because it's yours.
Because that's yours, right? You do have a right to ask the landlord to fix the broken sewer pipe, which is running, from your mobile home to the street, if where that pipe broke is the property of the landlord, and so you would have a right to that repair. But you wouldn't have a right to, for example, tell the landlord to come and treat your mobile home for rats or whatever, because you own that structure. Now, if you're renting the structure, then you have every right under the property code as a tenant. But RVs, they did take basically strip that from the property code, and that is a shame. You can sort of see the logic because they are able to physically move it. It's not a permanent structure necessarily, but in these times, folks are living in those as their permanent residence, and a lot of folks don't have any alternatives. So it is a shame that that depending on the situation, they may not be afforded the same rights.
So let's talk a little bit more about the shame stuff. So in these times, right,
Yeah.
we see that people um, are openly racist, right? And maybe
Yeah.
some of these people that are openly racist are the property managers or landlords or whatever people that are
Right.
in charge of taking somebody's rent. So would you say, let's say for example that I'm a person of color and let's say you're the owner and let's say you're racist. I go to you and I say, hey, there's a problem, right? And I spend like maybe 2 or 3 months telling you, hey, there's a problem, and you never send anybody, you just never do anything. And then one day I go into your office and I'm like pissed. I'm like, fix my shit, fix my shit.
Right.
And then you call the police, and then you go and you put a paper on my apartment that says, you got in the way of doing business. I want you out. And does that mean that now I don't have a right? Now this person can really evict me because I got mad?
So that scenario that you described is actually very common. I would just begin by saying I'm not a so my work does not cover issues of discrimination. So issues of discrimination based on the protected classes, um, race, national origin, those things that falls under fair housing. And fair housing is an aspect that Austin Tenants Council covers, and they have excellent staff who are experts in that field and will help you and address that situation. If you feel like you're being discriminated against, uh, um, really, even if you don't know, but if you just feel, you should call Austin Tenants Council and tell them that you feel like you're being discriminated against. The situation you described, um, as a practical matter, the answer is that the landlord can ask you to leave. Okay.
Because I got mad in the office.
Well, that's right. 90% of the leases that are used in Austin, I would say 90%, are one of two leases. There's a lease called the Texas Association Apartment Association lease, and the Texas Association of Realtors lease. Those are two of the most common leases used, at least in Austin, probably in Texas. And those leases, they basically protect the landlord from what they would term as interfering with the regular course of business, and they also have a provision in there for criminal activity, and so, but it's not clearly defined. So
it would be a crime.
well,
For me to
it's
be
not a
pissed off in
it's
the
no
office?
so it's not a crime, but what the viewers have to understand or should understand is in sort of underpinning this whole idea that you're a tenant and you have rights is the practical reality that in Texas, a landlord has enormous power because primarily because there's nothing preventing a landlord from 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 alleging that you have done something which violates your lease. Okay, there's nothing preventing a landlord from alleging that, even in writing. And then if you and if they say that whatever you did broke the lease, and now you have to leave, if they complied with sort of legal process of giving you that notice and saying now you have to surrender your property within 24 hours, 72 hours, as a practical matter, there's nothing you can do if the landlord's not willing to work with you to prevent the landlord from continuing down that path. And if you don't leave, file an eviction. The sort of overarching notion here is this thing called good cause. There is no such thing as good cause for private residential tenants in Texas. A landlord does not need to meet a certain threshold to say you have broke the lease and now you need to get out. This may be a bit of an exaggeration, but if your lease says you can't have plants on your porch and you have plants on your porch, that's a breach of the lease. Okay, and the landlord can ask you to leave. Again, this may be sort of a bit of an exaggeration, but the landlord technically could ask you to leave because the lease clearly says you can't have this on your porch, and you do. And so now he's asking you to leave, and if you don't leave, which you have a right not to, the landlord can pursue that down the road through to an eviction filing. And the question of whether or not that breach of the lease is actually a material breach and serious enough to warrant demanding possession of the property and filing an eviction, that question is only ultimately answerable by a court. And by that time, your credit's ruined,
right?
Because they filed the eviction. So it's really the lesson is don't get on the bad side of your landlord, right? Because they don't need to meet a certain threshold in order to ask you to leave, in order to sort of allege that you breached the lease and now you need to get out. There's, I mean, if you have a sort of a flighty landlord that says, I don't like the way you look, right? Not very seriously. I'm sure there are folks who have been discriminated against based on their right. That's right. So and by the time they get to court, it's too late for their credit. Okay, it's too late now. Even if they win in court, the burden is going to be on the tenants to basically take that court judgment and have to go through the long, arduous process of disputing that eviction reference, which will appear on their credit. So that's why I say in Texas, the sort of the underlying sort of lesson that folks who may be listening should understand is, as a tenant, you're sort of inherently in a vulnerable position. You don't own your property; it's not your property. You're renting it, and if a landlord, if you get on the bad side of a landlord, and they allege that you breached the lease, you are really in a predicament in which you don't have a whole lot of leverage to begin with. Now, I'm speaking primarily for folks who don't have $250 an hour to hire a lawyer. Okay, I'm speaking about myself and the vast majority of folks in Central Texas who can hire a lawyer for $250 an hour. Those folks really need to be careful about how they go about living in their dwelling and adhering to the terms of the lease, because there is no such thing as good cause in private residential. In federal subsidized housing, it's different. But in private residential, you pay full market. You're not getting anything from the government. The property's not getting anything from the government. You're just living there as a residential tenant in the private market. It's not really a happy thought to think about, but you sort of are in an inherently vulnerable position. I'll give you an example of how bad it is in my view, my personal view. The law says we talked about eviction earlier. The law says you have to be given the notice saying get out, 3 days or less, depending on the lease. There is nothing in the law which requires that notice to tell you why you have to leave.
So they can just want you out because maybe they want their family member to move in or something.
There is nothing in the law that says that notice literally needs to give a reason. It can literally say, this is your notice to vacate. Your right to occupancy is being terminated. If you do not leave within 3 days or 24 hours, whatever the lease says, I will file an eviction. Signed, the landlord. That's all it needs to say legally.
So even if you have paid your rent, even if you have abided by it.
So I'm not saying even if you've done these things. I'm merely saying that that's all the landlord needs to do. Okay. So you may think that you're in full compliance with your lease. You may think you've paid rent on time and in full and in an approvable manner. You may think all these things. You may assume all these things. And you may show up one day and there is a notice on the inside of your door, because that's one of the legal ways that a landlord has to deliver the notice. And it says, give me back my property in 3 days or I'm going to file an eviction. And that's all it needs to say. And the landlord has no, to my knowledge, again, I'm not a lawyer, but to my knowledge, a landlord, uh, because that is all a landlord needs to put in that notice legally, according to the statute, it is possible that the first opportunity, and this seems unconscionable to me if you think about it, the first opportunity that you as a tenant would have to understand why you are being asked to leave potentially could be when you appear in court, when you're standing in front of a judge. You could literally think that you're in compliance, full compliance with your lease, and not understand why you've been given a notice to vacate. And there's nothing in the law which demands that a landlord tell you ahead of time, in writing or otherwise, why they're asking you. I mean, that sort of boggles the mind, right? I mean, what's the purpose of a notice if not to tell you something? But the notice doesn't need to explain why they're asking you to give up the property. But that is state law. So people just need to be very careful. Now, I'm not saying landlords are going to be so callous as to totally ignore you if they give you a notice to vacate. I'm just saying that technically that's the situation, and it just seems absurd that the idea that you don't have a right to know why you're being asked for the property that you live in, right? Your house, your apartment.
So
You don't have a right until you get to court. Like that's absurd.
so let's go to before you sign the lease, before you move in. So what would you say? Let's say you have limited coins, and so your choices are, reduced,
Yeah.
and you have to live somewhere. So you go to this place, you're not real sure about it, and you sign. It turns out that maybe before you got there, they sprayed for cockroaches with something that doesn't smell bad, or that you can't smell, but the
Right.
cockroaches can, so you don't see any. Let's say they banged on the walls or something, and all the rats went to go hide, and a couple hours later, everybody comes out. The cockroaches and the rats,
Yes.
they come out.
Yes.
So you signed your little paper. You have to live there.
Do you have to live there? You don't have to live there. As a practical matter, in the physical world, nobody can force you to live anywhere. But the better question is that a contract, and are you liable for it? And
But okay, let's say you want to live there because they're
right,
only charging you
right.
whatever to live there. Can you make the landlord fix the cockroaches
You
or not fix, but get rid of them and
you
get
can
rid of?
ask, and you have to ask actually in a very specific manner. The law places the burden on the tenant initially to request the repair, to request the pest control treatment, to request that they fix the plumbing, whatever it is. The law says that the tenant bears the initial burden to be current on rent, and at the time that you're current on rent, to make the repair request in a very specific manner in writing. There's a whole statute, provision of the statute that addresses it. That the burden is on the tenant. So yes, to answer your question, in a situation like that, where unfortunately you have not seen the apartment that you're about to sign a year lease for, that
Yeah, let's hear.
hold on, that 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 you will be held liable for that lease. And you put the key in the door for the first time, you open the door and it appears uninhabitable. Well, that's sort of a vague notion that for which there's no statutory authority uh, that would determine what is and what isn't habitability. In other words, or habitable. In other words, there's no commissioner, there's no uh, state agency which you can call and say, hey, I want to know if my apartment's habitable. So you turn that key for the first time, and the sink doesn't work, and the fridge doesn't work, and there's rats running around. Any reasonable person would say that's not habitable. But in fact, as a counselor, I have had cases where that was exactly the situation, and they were held liable for that lease. I had to tell that tenant, well, I'm very sorry, but you signed that lease, and the law says that the burden is on you, not the landlord, you initially, to request the repairs. Okay, even though it seems sort of commonsensical that if you're renting a place to live in, that it ought to be livable at the time that you rent it, at the time that you sign the lease. And in fact, not to get too much in the weeds, but the repair statute, uh, if 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 there's any nerds out there and you want to look up the repair statute, Chapter 92 Texas Property Code, you look at the repair statute and go to the very end of that statute. The very end of that statute, there's a footnote. It's what's called the legislative history, and that footnote prior to the legislative history states that the the um, the repair statute that's provided for by by the law, that statute um, is it replaces common law. It is in lieu of common law. It abrogates common law. In other words, common law since time immemorial, uh, maybe not that long, but common law basically has always held, to my understanding, again, I'm not a lawyer, that when you rent a thing to live in, there's this notion of habitability, that it's going to be habitable, right? That you're going to be able to sleep there without getting bitten by rats. Okay,
You keep the outside out.
that's right. That's absolutely right. And that it's habitable initially. In other words, at the signing of the contract, of the agreement, that when you initially take possession, that it is in a habitable state. That's my understanding of the sort of common law understanding of the landlord-tenant relationship and the structure. Well, the repair law explicitly says at the end of the law that that sort of understanding is replaced by a tenant's obligation to request the repair.
So we're back to nobody's special, right? So it doesn't matter how much you think that people have respected you your whole life, your landlord can, in effect, disrespect you because of the way the law is set up, because of this phrase.
I mean, I would go so far as to say you're at an inherent disadvantage.
Yeah.
Yeah,
Nobody's
bad. Right.
So this is a very complex subject, and I really appreciate you coming out, and I hope that you come again. Uh,
I would be happy to.
so housing-rights.org is a website where you'll find all this information. It's based on the Texas Property Code, which is good for all of Texas. And as you've heard, it's a very complex issue. So if you're looking for information, call 512-474-7006 to request a face-to-face counseling session. There's some eligibility requirements. And then there's also that counseling line, also eligibility requirements. But again, if you have an address for Williamson, Travis, or Hayes, you can give that and be attended to. And that number is the 512-474-1961. And those hours are Monday through Thursday, 9 to noon, and 1 to 4, and on Fridays only from 9 until 1. And there is also a counseling online that folks can do. If you go to housing-rights.org and you go to, I believe it's online counseling.
It's services and then online counseling.
Perfect. Mm-hmm. So those are generally answered within 48 business hours. So Nomial is thrilled that you were my first guest on my first YouTube extravaganza live action show.
I loved it.
Do you want to eat your egg?
I'm good. Well, I just want to say that Austin Tenants Council is an amazing organization. Today I was here as a private individual speaking on my own and in my own opinion, non-lawyer opinion, but they are an amazing organization. If you have any issues, you should. If you're a tenant, you should absolutely call them.
Perfect. Thank you, Daniel.
All right. Thank you.
All right. Next, we're going to have wonderful Alice Sullivan, and we're going to take a short break.